Hi, I'm Paul Castle at the Castle Law Firm. Our firm handles a fair number of custody cases. When a couple that has a child or children together separate, one of the most important and imminent issues they'll have to deal with right away is the issues of custody, such as with which parent the child or children will live with, or which parent will have the authority to make major decisions about important events or major issues in the child or children's lives. Of course, the parents or the parties can resolve those issues by agreement, by coming together. But a lot of times that doesn't happen. That is not possible. When the parties cannot resolve these issues by consent or by agreement, they look to the courts for guidance and assistance, whatever form that might take. Over the years, the courts have developed a sophisticated and very systematic ways of thinking about custody. First, conceptually, the courts distinguish between different aspects of custody, that is, legal custody as opposed to physical custody. Legal custody has to do with a parent's authority to make major decisions about important events or issues in a child's life. Is the child going to enroll in a Catholic school, or is the child going to enroll in a Buddhist school? Is the child going to go through surgery to get the appendix removed or not? So those will be major issues or major events. Physical custody, on the other hand, has to do with which parent the children will live with. You may have heard about shared physical custody. If the custodial arrangement is shared physical custody, the children will live with one parent half the time and will live with the other parent the other half the time. It's like 50-50. You may have also heard about primary physical custody as opposed to secondary physical custody. In that case, one parent will have the children living with them most of the time, and the other parent, which is the non-custodial parent, will get to visit with the children time to time. But let's put these issues together, legal custody and physical custody. When courts try to determine the best custodial arrangement for a set of parents and children, they normally think in terms of the next three custodial arrangements or schemes. The first custodial arrangement or scheme is joint legal custody and shared physical custody. In that first scheme, joint legal, shared physical arrangement, the both parents will have the same and equal decision-making power to make decisions about important and major events and issues in the child's lives. When it comes to who the children stay with, it's really 50-50. The children will stay with the dad 50% of the time, and with the mom the remaining 50% of the time. If the parties are local, if the parties live in the same city, then a week on, week off is customary. The children will live with the mom for a week and then live with the dad for a week and go back and forth. If the parties, the parents, are 1 or 2 states apart, the duration where the children go back and forth may be a month by month. The children may stay with the dad for a month and stay with the mom for the other month and go back and forth. If the parents are really far apart, if the mom lives in North Carolina and dad lives in Texas, in that case, the alternating duration may be 6 months at a time, 6 months with the dad and 6 months with the mom. The second scheme of custodial arrangements the courts use will be joint legal custody, where one party has primary physical custody and the other party has liberal, reasonable, and specific visitation privileges. In that case, in this second joint legal custody but primary, secondary physical custody arrangement, again, both parents have the same and equal authority to make major decisions about important events and issues in the children's lives. But when it comes to who the children live with, the children will live with the custodial parent, the parent with the primary physical custody for the most part, for the vast majority of the time. But the children will go visit, spend time with the other parent, non-custodial parent, time to time. When the parties are local, when the parents live in the same city, normally the non-custodial parent get to have the children over at his or her place every other weekend from 5 o'clock Friday till 5 o'clock Sunday. And sometimes some Wednesday evenings will be combined. Other than every other weekend, the non-custodial parent will also get to have the children over in alternating holidays. Alternating holidays meaning Thanksgiving, spring break, and Christmas, and alternate. And then the non-custodial parent will also have the children over part of the summer vacation, normally about 3 to 4 weeks during the summer. In the same scheme, joint legal custody / primary, secondary physical custody scheme, if the parents are not local, don't reside in the same area, then the non-custodial parents' visitation may be limited to just alternating holidays, that is once again Thanksgiving, spring break, and the Christmas, and part of the summer. Of course, when I say the parties are not local, that might be a situation where the mom lives in Jacksonville, North Carolina, whereas the dad lives in Albuquerque, New Mexico. In that type of situation, every other weekend visitation with the children is not feasible practically. Obviously, they're not going to fly 3,000 miles every other weekend. So in such a situation, even though the non-custodial parent only does have joint legal custody, the non-custodial parent's visitation will be limited to alternating holidays and bigger chunk of the summer, not 3 to 4 weeks, but 6 or 7 or 8 weeks, normally from 1 week after school is out until 2 weeks before school begins. Now moving on to the third and final custodial arrangement, that is called the sole exclusive custody. In that case, the custodial parent, one parent, has everything: legal custody and physical custody. Only that parent has the authority to make decisions about the important events and issues in the children's lives. The non-custodial parent have no say in those matters. And when it comes to who the children live with, the children will live with the custodial parent all the time. The non-custodial parent does not have specific visitation privileges. Even in that situation, the non-custodial parent can have visitation with the children at the discretion of the custodial parent. So only if the custodial parent says, yes, you can have visitation with the children, then it can happen. Which custodial arrangement might be best suited for your situation is a intensely fact-based inquiry guided by the children's best interest analysis. Hope this video has been helpful, and if you have any further questions, please call the Castle Law Firm in Jacksonville, North Carolina. Our phone number is 910-347-3344. Thank you for watching.